The Supreme Court courtroom descended into a dense quiet as Justice Amy Coney Barrett rapped the wooden bench with her gavel. Sharp and authoritative, her voice cut through the tension. "Miss Leavitt, this court finds your repeated claims regarding our recent ruling deeply troubling. You are standing precariously near contempt." Behind the podium, Karoline Leavitt, the White House press secretary, stood firm, addressing the 9 justices whose decision would redefine her future. Only 28 years old, she was the youngest individual in U.S. history to be held in potential contempt by the Supreme Court. Justice Barrett, her voice tight but firm, went on, "You have 7 days to withdraw your remarks and make a formal apology, or this court will have no other option than to refer this case for criminal prosecution." The gallery gasped. Reporters' fingers blurred on their phones. But Leavitt didn't budge. Opening a leather portfolio calmly, she began to rifle through it. "Justice Barrett," she began, her voice steady, "I've prepared a 15-page legal analysis explaining why my statements are not only protected but legally correct." What followed would send shockwaves through the court, the media, and the nation. Before delving further into this unprecedented legal confrontation, don't forget to subscribe to our channel and share your thoughts in the comments about the limits of free speech and respect for judicial authority. Installed in 2020, Justice Amy Coney Barrett had established herself as a force to be reckoned with on the conservative-biased Supreme Court. Her razor-like legal acumen and unyielding personality earned her respect from both sides of the ideological spectrum. A constitutional scholar and former Notre Dame law professor, Barrett was especially attuned to public denunciation she perceived as factually misguided or legally erroneous. Karoline Leavitt, on the other hand, represented a new generation of Washington politics. Already 6 months into her role as White House press secretary, she had earned herself a reputation for bluntness and ferocious devotion to the policies of the administration. Few were aware that she had graduated with distinction from Street Anselm College with majors in politics and communications and low-key but intense law studies pursued during earlier government service. The flame that fueled this clash was lit 3 weeks prior, when the Supreme Court delivered a contentious 5-4 decision in Fairfield versus Department of Education, limiting federal control over state education policy. At a subsequent press conference, Leavitt stated, "This decision is a basic misreading of precedent and legislative intent. Majority opinion overlooks 70 years of settled precedent and substitutes judicial discretion for constitutional principle." The unusually sternly worded denunciation brought with it an immediate backlash. Legal commentators discussed whether her statement constituted an incipient contempt. Right-wing outlets called for punishment. Left-leaning pundits defended her in terms of free speech. The stakes were high. A finding of contempt could result not just in imprisonment, but also end Leavitt's promising professional career. For the Supreme Court, and especially Barrett, this was a moment that pressed the boundaries of judicial power in an era when institutional respect was wearing thin. Could the executive counterpoise the judiciary without suffering legal retribution? The court order to have Leavitt appear before all 9 justices sparked national interest. Law professors searched history for analogs. The New York Times called it a constitutional crisis without contemporary precedent. The Wall Street Journal dubbed it a collision between judicial power and executive communications rights. As Leavitt faced the chamber, the solemnity of the occasion was clear. Her lawyers had called for a prompt apology. The White House counsel's office prepared a penitent statement. Even the president recommended a conciliatory tone. But Leavitt had worked 3 sleepless nights researching court precedents involving contempt, free speech, and inter-branch criticism. What she found persuaded her to take another path, one that might vindicate her ideals or finish her career in spectacular style. With Barrett's ultimatum issued, the proceedings entered a critical juncture. Everyone anticipated a retreat and an apology. But instead, Leavitt took on a Supreme Court justice's reading of the law, a gesture regarded as political suicide by many. Barrett appeared visibly startled as Leavitt opened her file. A few justices looked on. Chief Justice Roberts leaned forward, plainly interested. Barrett cautioned, "Ms. Leavitt, this is not a debate. The court's stance is unmistakable. Leavitt smiled deferentially. I recognize Justice Barrett, but prior to this court continuing, I feel obliged to clarify the legal basis under contempt. Barrett furrowed her brow. Go on, but be mindful your words could impact the final decision of the court. Leavitt stood firm. Thank you, Your Honor. I'd like to begin with Bridges versus California. In that 1941 ruling, the court affirmed that criticism of judicial decisions, even harsh criticism, is protected by the First Amendment unless it poses a clear and present danger to the administration of justice. My statements, though direct, presented no such threat. Justice Alito broke in. Miss Leavitt, you charged this court with disregarding 70 years of precedent. That's not criticism. It's an assault on our integrity. Facing him, Leavitt said, Justice Alito, in New York Times versus Sullivan, this court enforced that public discussion must be uninhibited, robust, and open to wide-ranging and free discussion, including caustic or uncomfortably harsh criticism of public officials. That decision specifically embraced judges. Silence ensued as Leavitt continued, dismantling the claim of contempt point by point. In Craig versus Harney, this court determined that judges have to put up with criticism as part of a healthy public debate. What goes on in courtrooms is public domain, she stated, reiterating the principle that judicial rulings are not above examination. Barrett's tone mellowed, although it was still firm. Miss Leavitt, in those cases the defendants were private citizens or journalists. You are a government official responding in your official capacity. Leavitt, ready for this, turned to page 8 of her brief. Justice Barrett, I direct the court to Garrison versus Louisiana. There, this court defended speech by a district attorney attacking judges. The opinion stated, speech on public affairs is the essence of self-government. Witnesses sat stunned. This was no heartfelt tirade. It was a meticulously argued constitutional argument. Writers had stopped pecking at their typewriters, amazed by the direction the hearing had taken. Justice Kagan responded, Miss Leavitt, there's a distinction between criticizing a ruling and charging the court with intentional misreading. That requires bad faith. Leavitt also accepted the distinction. Justice Kagan, I recognize there is a line. But in Wood versus Georgia, this court supported a sheriff's ability to accuse judges of prejudice and political motivation, remarks considerably more pointed than mine. The decision was careful to note that elected officials need to be able to comment on issues of public importance. Barrett's tone changed further. What had begun as a scolding was becoming an argument. Miss Leavitt, she said, you've referred to cases but none directly address statements by White House officials regarding court decisions. That's true, Leavitt conceded, but I would say the absence of restrictive precedent favors protection. As this court explained in Texas versus Johnson, we are dedicated to keeping debate on public matters uninhibited and robust. Justice Thomas, typically reticent at last, spoke. Miss Leavitt, your argument is persuasive. But what about the institution? Your remarks can undermine public trust. Leavitt held his eyes. Justice Thomas, I understand that concern. But in Landmark Communications versus Virginia, this court decided that damage to reputation is not sufficient reason to muzzle speech. The opinion actually went so far as to state that judges should not use the dignity of office as a hiding place from public disapproval. The courtroom came alive. Justices leaned forward in their seats. What had started as a rebuke was now an all-out constitutional reckoning. Leavitt wasn't asking for mercy. She was insisting on legal acknowledgement. Barrett, rethinking, leaned forward. You're suggesting there is no limit on how administration officials can describe court decisions? Not at all, Leavitt said. Direct encouragement to ignore a decision would be too much, as in Bridges. But sharp criticism of legal argument would be well within the limits of protected speech. As she went on with her careful examination, the atmosphere in the room shifted. A scolding had turned into a jurisprudence seminar, conducted by the youngest individual in the room. Her mastery of precedent had obviously taken the justices aback. The room was silent while Leavitt turned the page. Her voice, even stronger now, projected. If I might, I'd like to put my remarks in perspective. Barrett, who had been poised to issue a warning, instead nodded slightly. The discussion had shifted. Leavitt went on. Presidents have long attacked this court. Jefferson scoffed at Marbury versus Madison as twistifications. Jackson famously declared, "John Marshall has made his decision. Now let him enforce it." Lincoln rejected Dred Scott in his inaugural address. She stopped and let the significance of that history be absorbed. In 2010, President Obama publicly criticized Citizens United in his State of the Union address. In 2017, President Trump called a ruling judge a so-called judge. Neither were held in contempt. Justice Sotomayor broke in. "Those were presidents. Your role is different." Leavitt replied quickly. "With all due respect, Justice Sotomayor, the legal test for contempt makes no distinction between presidential and executive branch rhetoric. Historically, press secretaries, from Ron Ziegler to James Brady to D.D. Myers to Kayleigh McEnany, have all made criticisms of court opinions. And then her most biting maneuver, a direct comparison of her own words to the legal standard for contempt. If I may draw the court's attention to the precise language I used." She started calmly, waving a copy of her previous press conference. "I said that the decision is a basic misreading of precedent and legislative intent. This is a legal judgment, not a personal criticism," she declared. "The majority opinion disregards 70 years of settled jurisprudence. This is an argument about legal methodology, not judicial integrity." She addressed Justice Barrett directly. "Under Bridges, contempt must involve clear and present danger to the administration of justice. My comments do no such thing. They criticize legal reasoning, not judicial legitimacy." Justice Barrett, who had entered the room assertive and ready to scold, now found herself confronted with an unexpected twist. The young press secretary was not issuing an apology. She was presenting a technical constitutional argument based on the court's own precedents. "Miss Leavitt," Barrett said, attempting to reassert control, "while your familiarity with precedent is impressive, there is still the matter of your role. As White House press secretary, the words of your mouth have the implied weight of the executive branch." Leavitt had anticipated this. Turning to the final section of her analysis, she replied, "Justice Barrett, that's an important distinction I'd like to address. In Garcetti versus Abalos, this court held that public employees speaking within the scope of their duties may receive less First Amendment protection. However, that case clearly distinguished between internal workplace speech and public commentary on matters of public concern. She talked clearly and confidently, mentioning page numbers and quoting opinions directly. Clerks struggled to check her sources and found them correct. In addition, she went on, in Lane versus Franks, the court explained that speech by public employees regarding matters of public concern is entitled to robust protection. A Supreme Court ruling defining national education policy is clearly a matter of public concern. As press secretary, part of my responsibility is articulating the administration's position on such issues." The gallery was quiet, transfixed. What was meant to be a moment of discipline had become a lecture on constitutional law by authority. Barrett, sensing the conversation was no longer on track, changed tack. "Ms. Leavitt, this court has the ability to protect its institutional integrity. Beyond legal technicality, your words seem to be disrespectful." Leavitt nodded deferentially before delivering her strongest reply. "Justice Barrett, I respect this court greatly. It's for that reason that I think free speech about its rulings is important." She then cited Barrett's own words from a 2019 Notre Dame Law Review essay. "Respectful disagreement is not disrespect. Indeed, the ability to criticize judicial reasoning is essential to the health of our constitutional democracy." A stunned silence ensued. The room waited on her words, Barrett's own words, quoted verbatim and in context. A few of the justices stared at Barrett, expecting her to say something. The moment hung there, tense, before she broke into it. "Miss Leavitt, thank you for the completeness of your argument. The court will consider the points you've made under advisement." She scanned the room and nodded toward Chief Justice Roberts. Roberts turned to Leavitt. "The court will make a ruling within 48 hours. This proceeding is adjourned." As the justices rose to depart, the courtroom hummed with quiet talk. What had promised to be a routine rebuke had become something much more significant, a powerful defense of free speech made at the highest echelons of government. Outside, Leavitt was met by a wall of flashing cameras and shouting reporters. She remained composed and said only, "I've presented my position to the court out of respect for their deliberative process. I'll reserve further comment until a decision has been issued." Her restraint only magnified the moment. Within minutes, legal scholars and commentators across the country began analyzing what had just occurred. At Georgetown Law, Professor Lawrence Tribe told a stunned group of students, "What we witnessed was unprecedented." A press secretary transformed a contempt proceeding into a First Amendment seminar, citing the court's own cases with precision. On CNN, Jeffrey Toobin was on screen and seemed electrified. "I've covered the Supreme Court for decades. I've never seen anything like this." Leavitt didn't just defend herself. She lectured the court on its own doctrine. Even right-wing analysts were impressed. Michael League, a former federal judge, said, "Although I disagree with her reading of the court's decision, her arguments were well presented. The constitutional questions she raised are serious and warrant careful consideration." As opinions poured onto the airwaves and social media, a new trend was spun: Leavitt's secret legal pedigree. Until recently, her law background was little recognized. That all changed in a hurry. The Washington Post published an in-depth profile titled "Behind the Podium: Karoline Leavitt's Unknown Legal Background." It revealed that she had completed a rigorous evening law program while working full-time on Capitol Hill, maintaining a 3.9 GPA throughout. A former professor, speaking anonymously, described her as one of the most gifted constitutional law students I've ever encountered, able to quote cases from memory and apply them with rare insight. Within the White House, the atmosphere changed from crisis to guarded pride. Staff who had prepared an apology were left astounded by what Leavitt had produced. Nobody had any idea she'd spent the whole weekend constructing a complete constitutional defense, one senior advisor said. Even the president himself, initially worried about political repercussions, phoned her personally. Sources quote him as simply saying, "You made history today. Whatever comes next, I'm proud to have you on this team." In the Supreme Court, meanwhile, an emergency conference of the justices was taking place. These extraordinary deliberations indicated the gravity of the question Leavitt had posed. Justice Barrett is said to have initiated the discussion. "We were anticipating a run-of-the-mill contempt hearing. Instead, Ms. Leavitt had filed a considered First Amendment defense based on our own cases. We need to respond with care." Although opinions were mixed, some justices quietly expressed respect for Leavitt's legal acumen. Justice Kagan is said to have said, "Whatever we decide, we've all developed new respect for her constitutional sophistication." Law schools acted promptly to the moment. Harvard promulgated a special symposium, Executive Speech and Judicial Criticism. Stanford hosted a panel of former Supreme Court clerks. Overnight, articles materialized in top online law reviews. The Yale Law Journal featured a forum essay entitled "Contempt, Power, and Criticism: The Court's Dilemma After Leavitt." It examined the court's tough choices, either backing down and upholding her argument, or charging contempt even though she had a robust constitutional defense. Social media went wild. The hashtags #LegalGenius and #Supreme Showdown trended on Twitter nationally. Young women took to TikToks critiquing Leavitt's presentation and confidence. Millions viewed as the story went far beyond the legal community. 2 days afterwards, the Supreme Court made a decision. In a unanimous 9-0 decision, it declared that it would not take contempt action. The court recognized the First Amendment concerns at stake and reaffirmed the importance of strong debate regarding judicial rulings. Justice Barrett wrote a distinct concurring opinion that would be read for decades. While this court must safeguard its institutional integrity, we also have a responsibility to uphold constitutional limits. Ms. Leavitt reminded us that our precedents uniformly sustain important commentary, even when sharp or blunt. A democracy that cannot abide criticism of its courts is no democracy at all. It was not just a personal victory for Leavitt, it was a reaffirmation of constitutional rights. Legal historians would later mark the event as a turning point in executive-judicial relations. At her next press briefing, Leavitt remained composed. "I believe deeply in both the First Amendment and the importance of the Supreme Court. I'm grateful the justices engaged so thoughtfully with the constitutional questions involved." The effect was almost immediate. Law schools experienced booms in applicants, particularly women drawn by her path. Teachers witnessed increased student interest in constitutional law and separation of powers. Maybe most significantly, the tenor between the judiciary and the executive changed. Press secretaries grew more guarded and directed their criticisms at legal arguments rather than motives. And the court, in return, exercised more restraint in replying to political criticism. 6 months later, Justice Barrett asked Leavitt to give a talk at Notre Dame Law School. Tickets went on sale immediately and sold out. The moment marked a remarkable evolution, from courtroom confrontation to constitutional collaboration. Welcoming her, Barrett reminisced about their first meeting. "Ms. Leavitt reminded us that respectful disagreement makes our system stronger." Her brilliance surprised many, but it shouldn't have. In America, legal minds can spring up from anywhere. Leavitt approached the podium to a standing ovation. Her own path, from would-be contempt defendant to voice of national law, was now complete. What had started out as a move to stifle criticism had instead established a precedent for its protection. The press secretary had established herself as a legal force, not through institutions or titles, but through her principled invocation of the Constitution at a time when it was needed most.